Welcome back to our studio here in Tysons, Virginia. I'm Seth Berenzweig, and we are here to talk about a new and very important topic that impacts companies in and doing business in Virginia. And to kick us right off, I'd like to bring in my law partner, Declan Leonard. Good morning.
Good morning, Seth. Great to be here again and talking about what's going to be a very important topic for Virginia employers in particular.
Absolutely. We're here to talk about major changes in the legal landscape for companies. And just to set the table, Virginia for decades was a little bit of a sleepy jurisdiction when it came to employment law. And in fact, the inside joke amongst practitioners was that there was really barely any Virginia employment law.
Nothing, yeah.
And there were a number of changes that have happened that are real huge game changers. We're going to focus on three of them today as highlights. And let's just jump right in. Let's start with the Virginia Values Act. This and the other laws are going to be effective at what time this year, and what's the bottom line on the new law?
So everything goes into effect on July 1st. So companies do have a few months to prepare to react and to adopt to this new legislation. You know, it's interesting. You talk about Virginia being sleepy. In the car ride over here, I was listening to the radio, and they were talking about how it's the 25th anniversary of the movie While You Were Sleeping, the Sandra Bullock classic. I know, Seth, you're a major rom-com fan, so I know you probably know it better than I do.
Can't get enough of it.
But While You Were Sleeping, I mean, it's so relevant to what happened here. We're in the midst of this pandemic, and nobody really saw this happening down in the Virginia legislature. But what they did down there in terms of employment law has really been seismic in terms of the changing the landscape. I heard one quote that says, you know, Virginia is the new California. I don't know if I'd quite go that far. We don't quite have meal breaks and rest breaks all over the place, but we're getting there with what we're going to be talking about today.
So if I'm an executive leading this company, and for example, if I'm an HR director or anyone who's really in charge or involved with management of the company, why is this change of Virginia law such a big deal?
So for the longest time, the Virginia Human Rights Act, I mean, for lack of a better phrase, it's really been kind of a toothless law. There really has not been much bite to it. It only applied to very small employers with only a few employees, between 5 and 20 employees generally. And it really did not give much of a cause of action. The press is talking a lot about the fact that under this new Virginia values legislation, it's added two new categories for protected classes, and that's gender identity and sexual orientation. But I think we could talk about actually even the bigger changes that maybe are missing the mark in terms of what you're reading in the press.
Right, and how is that? Because, and I'm glad that you brought that up, because when I first read about it in the press, it really gave me the wrong impression that you just have these two nuances and everything else is the same, but that's not the case at all. In a real day-to-day change effective July 1, what's the real bottom line as it relates to companies in Virginia?
So what they did under this legislation is they created a new cause of action. In other words, employees can now sue employers for any of these protected classifications for changing the terms and conditions of their employment. It doesn't have to just be a firing or a discharge. It can be lack of promotion. It can be demotion. It can be anything related to that, pay issues and things of that nature. And so what it's done is it's created the ability for Virginia employees to now sue their employers in state court, and that's one of the key things. State court versus federal court. We're well familiar with these cases litigated in federal court.
Right. So in other words, although it hasn't really been depicted with the full context by the media in the DC region, the reason why this is such a big deal is that it has effectively blown open a brand new door in state court, in the applicable Virginia Circuit Court, to a brand new cause of action for discrimination in Virginia that effectively, for the vast majority of companies, never existed before. And now you can get damages, you can get costs, you can get attorney's fees. And this is something, is this new? Is this something that from July 1 forward is going to create a whole new envelope of cases that never existed? And why is it important to realize that this is something that can sit in a state court as opposed to just going into a federal court?
We cannot overstate this. This will completely change the way lawsuits by employees for discrimination are brought in Virginia. Up until this point, again, we talked about the Virginia Human Rights Act, and up until this point, there really was just nothing that employees could do. You could go in and maybe get some back pay wages, but there was very, very little remedies for employees. In fact, in my 25 years of doing this, I don't think I ever handled litigation that involved the Virginia Human Rights Act. Whenever you're talking about Virginia litigation, you're talking federal
Exactly.
Title VII.
Right.
That is now all going to change. Everything I predict on the plaintiff side by employees is going to be brought in state court under this new Virginia Values Act.
And the reason why that's important, and I know that you were going to roll right into this, but just to share that point.
Definitely.
In federal court, they have a summary judgment law which says that you can get some testimony, you can get some evidence, and just ask the judge to just throw the case out before a trial. Very, very much harder to do that in Virginia. It's not impossible, but it's virtually impossible. What this means is that if you have a case and it states a claim on which relief maybe could or could not be granted, it's probably headed to trial. It's a new headache for employers in Virginia, and that's why it's a big deal. In order to be able to keep things moving, let me also just jump to the next change, which is the worker classification law. Why is this a big deal, and why is this such a seismic change as far as companies in Virginia are concerned?
Yeah, this is perhaps even a more seismic change just because most states don't have what's called a private right of action. So if you're an independent contractor, let's talk about it a little bit, why this even matters. You, as an employer, sometimes you'll have your W-2 employees, but sometimes you'll also have independent contractors that you issue a 1099. Particularly in the DC region, we see that a lot with government contractors, and they have sort of a combination of both in their workforce. And the federal government has talked about clamping down on this, and misclassifying is what they say. Basically saying you're calling somebody an independent contractor when they really should be an employee.
Right.
Now Virginia has gotten into the mix and said, independent contractors, you now have the ability to sue your person paying you, basically the company, and say, I was misclassified. I should have been getting health insurance. I should have been getting the employer share of FICA. I should have been getting all of overtime. I should have been getting all of the other things that regular employees have gotten over the years.
Exactly, and I think that this is arguably the most important change, or at least a tie with the Virginia Values Act, because for many years in Virginia, companies had a lot of flexibility to misclassify people, whether they were an independent contractor or a W-2 employee, and there were really virtually no ramifications of that under Virginia law. Now, effective this summer, all of a sudden there's going to be a whole new cause of action where someone believes that if they were misclassified, they can file a new cause of action in Virginia court, and they are able to seek not only their pay, but attorney's fees, costs. There are monetary penalties for each violation, and this is something that really wasn't even on the radar screen beforehand.
Yeah, there's another aspect to this that's critical. There is now, under this law, a presumption that anybody who's doing work and is getting paid for doing that work, there's a presumption that that's going to be an employee, not an independent contractor. It is a rebuttable presumption. In other words, you can come forward, and we have lots of clients. We do this. We advise them. We do what we call employment audits for them, so that we can go in and say, is this truly an independent contractor? We have lots of employees that properly designate some of their laborers as independent contractors. But now the burden is going to be on the employer to show why they should be truly an independent contractor as opposed to an employee.
So now not only are companies going to get dragged into court based upon a brand new claim, but on day one, they've got to have the burden of proof, even though they're not the plaintiff, which is, again, just a game changer. To go to the third of our three topics for today, let's talk about the Virginia Wage Payment Act. This is the third piece that we're going to talk about. Walk us through this and why this is such a big deal.
Yeah, so what we're talking about here is any claim by an employee that they just were not paid properly. Whether they were not paid properly for overtime, whether they were not paid properly for commissions. We handle a lot of these high dollar commission disputes with executives and with in the sales realm, in the IT sales realm. And so, now you're going to have a private cause of action. Up until this point, if an employee felt in Virginia that they were not paid properly, they would go to a specific agency within the state government.
A very dry and sleepy remedy. at that at
It
best.
was, exactly. Employers
Yeah.
didn't exactly cower when they found out that they were going to
Right.
get, like, a
Right.
complaint like that.
Pretty soft stuff.
Yeah, now they can go into court. I mean, the courts in Virginia are going to be flooded with these
Yeah.
claims.
Brand new
They can
claims.
go in, they can not only get their pay, they can get what's called liquidated damages, which is generally going to be, sort of the same amount as what they were owed. They can
Right.
get attorney's fees, and they can even, in certain circumstances, get triple damages of the amount. So if they were owed, 50,000 in unpaid pay, you're now looking at a claim that could really get up into the six figures, $200,000 when you put in treble damages, attorney's fees, liquidated damages, and interest.
So this reminds me of what had been going on in Maryland. Maryland has had for years a very strong wage statute,
Correct, yeah.
which is really pretty scary for companies that get dragged into this, because if they have to deal with this reactively instead of proactively, they're looking at potentially treble damages, they're looking at attorney's fees, they're looking at costs that never existed in Virginia before this. Now suddenly this summer it's going to land in Virginia for the first time. So these are really major monumental changes that are right around the corner. So let me ask you, now that we've talked about these three major changes, if I'm a CEO, I'm going to say, okay, I'm hearing you, that's fine. But rather than just hearing about it, what can we do about it? What are the action items that companies can do now before, in a few weeks, these changes go into effect?
No, it's a great point. I think companies, executives, HR reps in Virginia are going to have a bit of a mindset shift. A lot of times in Virginia, up until this point, as we talked about, it's been somewhat toothless in terms of some of these remedies that employees have. And so employers could afford to be a little bit more reactive. Up here, this is happening. We got this administrative complaint.
Right.
I think now they're going to have to be a lot more proactive. They're going to have to
What can I do?
train their managers. We do a lot of training for companies and managers, and we're certainly going to be adding this into our mix of what we do.
Right. So you're talking about training. I think that we could also talk about, and these are things that can be done really within, say, roughly 2 hours or so. Auditing. Let's do talking about a financial audit with respect to taking a look at your wages, taking a look at your handbook. These are the sorts of things that if you take a close look at it, then you can make a determination of how you can avoid these kinds of problems moving forward, and then you can look at it proactively as opposed to reactively.
That's right. And the last thing that I'll point out is there is insurance that comes into play for employment practices and employment liabilities. It's called EPLI coverage, Employment Practices Liability Insurance. A lot of our clients have it. It certainly has grown in popularity over the years, but I suspect Virginia employers are going to be ripe consumers for getting EPLI coverage now that they know that there's so much more liability on the state level as opposed to what's always been out there on the federal level.
So what we've done today is we've talked about three major changes and what companies and executives can do about it. And I think that the timing of this is perfect because we have just a couple of weeks before these go into effect. And then that way, everybody can be proactive, take a look at it, and be ready. Because I'll tell you, if companies are not ready for it and they find out because they're going to be put into a defensive posture, it's going to be a lot harder to have to be able to hit this back.
Absolutely.
Yeah.
It's a critical thing for companies to be aware of and really delve into.
Great. Well, thank you so much for joining us today. Happy to bring these changes to you. If there's any way that we can help, just let us know. And in the meantime, stay safe.